Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
This is Serious Privacy. Here are your hosts, Paul Breitbart and Kay Royal.
On 27 April 2023, Washington State Governor Jay Inslee signed the My Health, My Data Act into law. This law, which has been adopted with lightning speed, will enter into force in less than a year, on the 31st of March 2024, leaving companies very little time to prepare. Our guest today has discussed this law a lot in recent weeks, including with Kay and myself, while we were in Washington, D.C. for the Global Privacy Summit. So this week you'll hear from Mike Hintze, member partner at Hintze Law PLLC, senior fellow at the Future of Privacy Forum, and affiliate instructor at the University of Washington School of Law. Despite the short time this law has been in preparation, Mike has written extensively about the consequences of the My Health, My Data Act and the unforeseen impact it may have. You'll hear a lot about his concerns today as well. My name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. So, Mike, we are absolutely thrilled to have you join us. It was just luck, fate, whatever you have it, that we bumped into you and you gave us your thoughts on the new Washington My Health, My Data law, and I think it's perfect timing to have it. But that being said, are you ready for the unexpected question?
Can you be ready for the unexpected question?
You can't.
I really can't. But let's go with something relatively simple. What was your first car?
My car was a 1979 Ford Mustang.
Ooh, what color?
Blue. And it was an awful car. I bought it with 130,000 miles on it, and it showed.
That's awesome. Did you get it as a teenager?
I did. I was 18 when I got it.
Oh, that's a wonderful car for a teenager. Paul, you?
I never owned a car.
Oh, is that not a thing in Europe, just to not have cars? Because
It's less of a thing. In any case, we can't get our driver's license until we're 17, 18. So it's not that we use a car to go to school, as you see in all the US high school series, at least. So I've never done that. And then I was a student, so I couldn't afford a car. And I usually, when I went home to my parents, I could drive theirs. So that was for me the easy way. So the first one from my parents that I drove was a Citroen C5, and then a Volvo, and now an Audi. I still share the car with my parents or with my mom right now, because we both live in the same city. We don't need a car full time. I commute to work by public transport. So it's the easier and more environmentally friendly option.
Oh, that's awesome. Okay, so the first thought that came to mind is, are you telling me then in Europe you can drink before you can drive?
Yes. Well, in most countries you can. By now it's more or less the same age, because when I was young in the Netherlands, you could drink at 16 and you could drive at 18. Right now it's both at 18, although there are ways where you can start your driving lessons at 17.
Here, average, I think you could start your, what do they call it, before you have your license, when you have a permit to drive. Used to be, I think in my state, you could start at 14 and get your license at 15. So pretty young. And then they moved the drinking age to 21. But wow. Okay. My first car is one that about every other year, I go online to see if I can find one. It was a 1976 Dodge Gold Duster special edition. It had a snakeskin print roof, and I think the engine was a 34 slant 6 or something. I'm not really an engine person, but it was a slant 6, which meant all of the valves were on one side rather than 3 on one and 3 on the other. But really, really cool car. And I didn't know at the time that it was, but I was working with a friend of mine to soup up the engine for, street drag racing. And my mother thought that because I wasn't driving it, I didn't want it. And so she sold it. Since I couldn't technically own it because I was 16, I guess I was 17 when she sold it because I had started college. Came home and my car wasn't there anymore.
Oh, poor you.
Yeah. And I paid for everything.
And you couldn't even get a drink to compensate.
And I couldn't get a drink to compensate. She replaced it with a red Vet, but it was a Chevette, not a Corvette. And I did not feel that that was an equal trade whatsoever.
Well, at least it was red.
Now we all have to go through and scrub our secret question answers to make sure that we don't say what's your first car, because that information's now public.
That is true. And I do use that one. But yeah, okay, never mind. I'll have to pick.
So Mike is the first one to actually realize that all of your secret questions are actually intended to get people to give their secret password questions.
So this is your phishing podcast.
Of course it is. So Mike, we are here not to talk about cars, not to talk about food, but actually to talk about privacy. And indeed, as Kay explained, when we were in Washington, D.C. for IAPP, you were, can I call it ranting about the Washington My Health, My Data Act? At least you were not so happy with it. But before we start with the why on that, what is the Washington My Health, My Data Act?
The Washington My Health, My Data Act is a bill that has now passed both houses of the Washington State Legislature and is now on the desk of the governor for signature, and it's expected to be signed, so it will become law. It purportedly is focused on filling gaps left by the federal HIPAA law. The HIPAA law in the United States is the law that covers at the federal level what are called covered entities. And those are hospitals and clinics and doctors' offices and pharmacies and medical insurance providers. And so the health data that those entities cover is protected at the federal level under this federal law that's been around for many years. In past years, there have been concerns raised that there's an awful lot of health data being processed outside the scope of HIPAA by fitness tracking apps and other scenarios. And this is purportedly focused on filling those gaps. Also, in light of the Dobbs decision by the U.S. Supreme Court striking down Roe v. Wade and the threats to healthcare, reproductive healthcare, sexual healthcare, threats to gender affirming care, there's been a concern about protecting the data of people seeking those types of healthcare as well. And so there's been a lot of support for it. There's been a lot of momentum behind it because of those very important objectives that are behind it. The problem with this bill, and I look at this from a perspective of now, what are companies that are going to try to comply with this bill now that it will become law? What are going to be the challenges? And there are a number of challenges with this bill. One is that it does much more than filling those gaps that I mentioned. It is drafted incredibly broadly. The definition of consumer health data has generated a lot of attention and a lot of focus because it potentially covers a lot of data, possibly, almost any type of personal data. And the reason for that is the way it's drafted. The definition of consumer health care includes a lot of categories, a lot of examples of things that are in a not exclusive list of things that are in, including efforts to obtain healthcare services. And healthcare services is another defined term that is also very, very broad. That means anything where a person is seeking to improve or learn about their health. So you can imagine a grocery store providing nutrition tips. Is presumably going in there and making purchase there could be considered a healthcare service. A retailer selling exercise clothes or running shoes could be providing a healthcare service. Almost any product is potentially revealing of a health status. And they also talk about inferences and derived data data that can serve as a proxy for other data. So anything that could be used to infer a health status is potentially, and you can imagine when you take that and combined with a private right of action where the incentive for plaintiffs' lawyers are to argue that, you buying, Ben & Jerry's ice cream and light bulbs indicates insomnia, and therefore should be true that information about those purchases should be treated as healthcare data. The risk that companies have of underclassifying and focusing on data that truly we would all think of as healthcare data potentially puts them at a lot of risk because others could make arguments that is a much broader definition.
So basically you're saying that everything that I purchase could somehow be related to health data if you want to. I mean, I can understand that if I, for example, go to a pharmacist and buy condoms, but if I buy rice and vegetables, that for me would not be health data. But somebody could infer that I'm living healthy, so by doing that, you could argue it's health data.
My intuition is that's not health data either. But you have these financial incentives via this private right of action where plaintiffs' lawyers are incentivized to be creative here, right? They're incentivized to find instances where something could be classified as health data, where they can make a credible claim that it reveals something about somebody's health status. And it might not be one purchase, it might be a series of purchases where, there's that old Target example from over 10 years ago now, where, unscented lotions and vitamins and large handbags, fed into the algorithm and created a likelihood of pregnancy, right? And so you think about those kinds of purchases and, it's not going to be intuitive. It's not going to be obvious. So a retailer looking at this saying, well, do I think of this purchase data as in or outside the scope of that law? That's a hard decision to make because, company or plaintiffs' lawyers will make the arguments that, that purchase plus this other purchase reveals X, right?
And we all know now with the profiles that are quite prevalent on everyone that the idea that this is not going to feed into a profile or it's not going to be an indicator of something related to health is pretty far flung.
Yeah, or at least potentially, right? And it's that potential that is the difficult thing from a company's perspective, trying to put in place compliance measures around this. So either you under scope by, saying I'm going to scope this to things that are, obviously health related or obviously reveal health status, or I'm going to throw it wide open and just be safe and apply it to everything. The problem is applying it to everything. Substantive standards under this law are so extreme that it would be very difficult and very costly to do that. And I'll give you a couple of examples. The consent requirements under this law. There's several different consent requirements under this law, but the baseline is that it requires GDPR level consent.
Right.
So specific, unambiguous, it can't be bundled. It has to be an affirmative act. Consent is required for virtually any processing beyond what is necessary to provide the consumer requested product or service. And, necessary isn't defined. So it doesn't say strictly necessary. So, is there some wiggle room there that, is reasonably related, close enough, or do they truly mean necessary? If they truly mean necessary, and again, the plaintiff's lawyers will certainly argue that, right? If they truly mean necessary, that means for common, benign, expected operational purposes of data that are not strictly necessary to provide a service or fulfill a transaction might require this high level of opt-in consent, specific opt-in consent, not bundled, or so every separate purpose might need a separate consent. There's a second provision that says anything related to sharing data requires a separate consent. So you're arguably already required because of the specific requirement or the definition of consent, but that requires a separate consent. And then anything that would require that would be considered a sale of data. And they use the California Consumer Privacy Act definition of sale of data for monetary or any valuable consideration. And that phrase valuable consideration in California has been interpreted very broadly to include a wide variety of scenarios, including third-party targeted advertising. And so the level of consent for anything that would require a sale, unlike CCPA, where that's an opt-out, this is not only an opt-in, but it's an opt-in kind of on steroids. It requires what they call an authorization, which is a written document that needs to be signed by the consumer. The document, the statute specifies a number of things that must be in the document, a number of specific disclosures. It has to include the specific consumer health data that is being sold. It has to have the name and contact information of both the seller and the buyer. And both the seller and the buyer need to retain this signed document for 6 years. And the document itself expires after only 1 year. So the authorization is only good for 1 year. So it's an extreme level of opt-in.
That doesn't sound logical.
So onerous that I think few companies would ever do it. And let me go to another substantive requirement under this statute that when tied together with this first one, that authorization for sale, I think it's a prohibition. It's so onerous because this would essentially be a prohibition on data sales, which could include online advertising, which could, given the definition of consumer health data, cover just about any kind of personal data. So this may be a ban on targeted advertising. And let me go one step further and tell you another reason why I think that's the case. The obligations under this act include data subject rights, as in most privacy laws do these days, a right to access, a right to delete. The right to delete, unlike virtually every other privacy law, has almost no exceptions. There is a limit exception for security-related purposes, but there is not an exception for compliance with law. So when you have a data retention obligation and somebody comes and asks you to delete that data, there is no exception. You have to delete the data. So you need to choose which law you violate. And not only that, within this law itself, remember I told you about that authorization requirement. It is a written document that needs to contain the consumer health data being sold. So this document will contain consumer health data, and you need to retain it for 6 years.
But you also need to delete it as soon as somebody asks.
All a plaintiff's lawyer needs to do is find a company that is offering this authorization, grant that authorization, wait a few days, and then ask for it to be deleted, and see which part of the law they violate, the obligation to retain the authorization or the obligation to delete the data. So it's a litigation trap, right? And so
how could this ever have passed the legislature? When Washington has been so reluctant to adopt an omnibus privacy bill, I think we've seen 3 or 4 iterations in the past couple of years. And now this one goes through in 1 year.
Well,
with faulty provisions.
The omnibus privacy bill did pass the Senate unanimously several years in a row. It got hung up on the House side because House leadership very much wanted a private right of action in it. And the Senate version did not have a private right of action. It would have been enforced solely by the Attorney General. This one does have a private right of action, so it overcame that objection on the House side from the House leadership. And I think the fact that this has also been so closely tied to the specific concerns around health data that it got more momentum than an omnibus privacy law did. Now, of course, as I talked about, I think this is much broader than something that's specifically focused on health data, or at least the impact is potentially very much broader. But I think those factors combine to give this one just that extra momentum to get over that hurdle that the other omnibus privacy bill that had been proposed several years in a row never got over.
So go ahead.
Well, and as we've said, go ahead. Well, okay. As we've said as times, it seems like laws only really get passed when the regulators have something that really motivates them to do so, especially if it's some sort of controversial law. So I guess the My Health, My Data Act passed because they had very strong motivations to make sure things didn't happen in Washington that they're happening. Let's be honest. Texas restricted internet service providers and apps from doing certain things, even collecting information in Texas, criminal penalties, things like that, maybe not necessarily in the same bill. So Washington was motivated to pass something that would make sure that the same thing couldn't happen in Washington. So it seems almost like a knee-jerk reaction. I mean, is that true, or is that just what it seems like?
Necessarily characterize it like that. I think, Washington is a very progressive state. I think there's a trend that we're starting to see where privacy law is being tied to other objectives, right? And in progressive states, that might be reproductive rights. Yeah. In conservative states, that might be parental rights, where we saw that law in Utah pass recently. It gives, parents, very high levels of oversight and control over teenagers' use of social media and other online services. So, I think we're seeing these, I hate to use the word culture war, but it's sort of those issues that there's a lot of passion about, where the country is very divided. When privacy law is getting tied to those other agendas, it creates momentum that I think results in bad privacy law. Because privacy law is very nuanced, and there's a lot of big ways things have been worked out. And, we've got history of privacy law and, what's worked and what hasn't. And a lot of that nuance and that subtlety and that experience gets lost when other agendas or other motivations are motivating the act of privacy law.
So how do we get rid of these shoddy provisions? Is there a possibility to ask for some form of constitutional review, or can a judge say, well, these provisions are just not applicable because they are contradictory? Is there any way to basically make sure that the law actually is not contradictory?
There's a couple of paths. If it's truly leads to an absurd result, and there's a couple of things that we haven't talked about yet that do that in addition to what we have talked about.
Oh, it gets
right. Yeah, there's more. I will, but let me answer your
Tell me
question,
more.
Paul.
Tell me.
The path for there could be a couple of paths for getting this fixed. One would be another piece of legislation that would be sort of a cleanup bill. The challenge is that Washington State has a part-time legislature. We are 2 days from the closing of this year's session. And so there's just not time
for all of 2023.
And so there is just not time to fix this. The next session will open in January of 2024. So that would be the next opportunity to do a legislative fix. Short of that, and one of the other problems with this bill that we'll talk about in a minute, makes that timing particularly troublesome. Short of that, the courts will sort it out. There's a lot of things here that are ambiguous, subject to different interpretations. There are things that I would characterize as drafting errors that create some either nonsensical or contradictory results. And, the courts could say, well, that was clearly not the legislative intent. I'm going to rule that this doesn't actually mean that. It means something else. But, getting to that point will be costly. That's expensive litigation for a company to defend themselves against claims from plaintiffs' lawyers who will exploit these problems and ambiguities in the law. And some company may not have the appetite or the budget to fight that and may just go for the quick settlement. So that's sort of the two paths by which some of these things could be, quote, fixed. So yeah, neither are particularly promising at the moment.
Was there a lot of debate on this one from consumers or interested parties as it was going through the process?
It didn't go very quickly.
It seemed to go pretty quickly from what I could tell.
And, advocacy groups were supporting, reproductive rights or consumer privacy generally were supportive of it. The sponsors, the state attorney general's office, were supportive of this and got behind it. The opposition came mostly in the form of industry groups. Few, if any, companies wanted to stand up individually and oppose what was being put forward for, positive and important, noble reasons, and they didn't want to.
Right. So any objection to it by a corporation or a company would have seemed like
So
they
it came
didn't
in the form
support
of
the
industry
underlying
groups,
intent.
trying very much to say we're not opposed to the objectives here. There are real problems with how it's been drafted and what that will mean for companies that will, certainly make good faith efforts to comply with its provisions.
Right. So, okay, tell us about the more troublesome parts of it.
So, compared to some of the other things, we talked about the consent issues. We talked about the deletion challenges with the lack of exceptions. There's a notice provision in there that seems to requires a health data privacy policy, which seems to be a separate document from the company's general privacy policy. And there's other privacy laws that require you to have sort of the general privacy policy with a long list of things that need to be in a notice. This seems to require a separate document that has, a lot of those same things that would be in the general privacy policy, just specific to consumer health data. But as I said, consumer health data is potentially almost anything. And so it looks like companies may have to have a separate document that is redundant of their general privacy policy with a separate link in the footer. So that's worry. That's make sure your homepage more cluttered with, the ever expanding number of privacy links you need to have between California and now Washington and, everybody else.
Right.
There's another provision in there. Well, there's a series of provisions. Under Washington state law, if a piece of legislation does not have a specified effective date, it comes into effect 90 days after the close of the session. As I mentioned, the close of the session is in 2 days. So that would mean July of this year, late July of this year. The first
You're going to
version
tell us this did not have an effect.
The Senate added an effective date, but the way it added the effective date was problematic. They did it on a section by section basis. Not every section added an effective date. So there's a prohibition on certain geofencing provisions around physical facilities that provide healthcare services. We can talk about that later if you want. That does not have an effective date specified. So that will come into effect in late July of this year. So in just a few months. Other substantive requirements, the way they added the effective date is problematic because each one of those sections has subsections. And each subsection sets out a separate requirement under that section. The way they added the effective date was part of the first subsection and part of a complete sentence that lays out the requirement of that first section. So it says, in effect, starting on March 31st, 2024, which is the effective date that's specified. So pushes it out a year. A regulated entity shall, and then it lays out the requirement, and then there's a period. And then it jumps to the next section. And the next section is silent on the effective date. So some have argued that effective date should be read as applied to the entire section. My argument is that is far from clear because that's not how the English language works. You have a specific requirement.
Yeah, that's not how the law works.
With a period at the end. And as part of that sentence, you say starting March 2020, March 31st, 2024. And then you jump to a separate subsection, a separate sentence that is silent on effective dates. My concern is that a plaintiff's lawyer will argue that second section and every subsequent subsection under that does not have an effective date and therefore will come into effect in late July 2023. And if I were a plaintiff's lawyer, I would be hoping to catch companies off guard because the general idea out there is this thing doesn't come into effect until March of next year. if I were the plaintiff's lawyer, I'd file cases in late July.
Well, companies should consider themselves warned right now because you told them.
I am trying to warn as many people as I can about this because I think it's a real concern. And I don't think, the plaintiff's lawyers would not have missed this. And so I think it's important to kind of shout from the rooftops, hey, if you think you have to March 2024, think again. You need to look section by section and think about which provisions may very well come into effect in just a few months, and what kind of risk mitigation strategies can we put in place to address that possibility.
This sounds very much like China or Vietnam.
Right. And
that's contrary to the legislative intent. And there's actually some language. Yeah, well, and I think different people can look at this differently, but I think there is at least a significant risk that plain reading that has an effective date for one sentence and then subsequent subsections are silent on it. I think there's a real risk that a judge would find that means that, by default, those other subsections come into effect in 90 days. So, I think that was a drafting error.
Crazy stuff.
I actually think my understanding is that it was intentional on the subsection, it was intentional on the section around geofencing where that entire section is silent on an effective date. My understanding that part was intentional. The rest of them, where it was done just in that first sentence of the subsection, I think that was a drafting oversight. And I don't think that was intentional. I think that was contrary to the legislative intent. And folks can argue that in court, but, we're arguing against what the statute actually says.
So is this it, or is there more?
I got a feeling there's more.
There's a few other issues. One thing that is interesting that also expands the effect or the reach of this is that it applies to consumer health data, which I've already, described as being potentially very, very broad in terms of data types. It's also very, very broad in terms of data subjects, because consumer health data is health data related to consumers, and consumers is a defined term under the statute. Consumers is defined as, and I'm paraphrasing it on the language right in front of me, as a resident of Washington State. All right, that makes sense, right? Or somebody whose consumer health data is collected in Washington State. All right, that makes sense. Somebody travels to Washington State to receive healthcare services, and their data is collected in Washington State. They're protected by that.
Fair enough.
The problem is that the term collected is also a defined term. And the term collected is defined to include the term process. I'm just going to pause and let that sink in for a second.
Ooh.
And process means exactly what process means under the GDPR.
Wow.
Any operation on data. Any sidetrack data.
Yeah, a Texas company with servers in Washington State would be covered.
Exactly. So if data ever touches Washington State, even if the consumer never entered Washington State, has no connection to Washington State, that consumer's health data would be covered by this act. And where are some of the largest cloud service providers headquartered? Washington State.
In Washington State.
So
say I'm using Microsoft Office and I'm not aware of server locations. I'm typing something medical here in Europe. Could that already trigger, in theory, the application of the My Health, My Data Act?
Now, some of the larger cloud service providers.
There is no threshold in this law about the number of consumers that need to be impacted, as we see in so many of the
No, there is not. One consumer could be enough to trigger it. There is a provision around small businesses, but that's defined based on revenue numbers of the business. And the only difference for small businesses is that they have a later effective date. Yeah.
90 days deferral, right?
Yeah.
So yeah, that just pushes
Yeah.
it over the summer to October.
This law that covers a wide swath of data that has impact well beyond Washington, geographically Washington state. The impact of this, I think, is very significant, which is why I've called this, perhaps the most consequential privacy law since the original CCPA was adopted in 2018.
Well, let's tell our listeners, consider yourself warned and start looking at this in more detail, because until we see some legislation, it might very well be that you could be the subject of this litigation that Mike has been foretelling. I would be scared of this, especially if I'm a US company, but even from the European perspective, I'm starting to get a little scared and probably will need to start doing some double checking and telling people to start double checking whether they have any relations with Washington state.
Yeah, because there cannot be a amendment to the bill until next year, as y'all heard Mike explain. Washington's one of
So
those
on that
states.
very happy note, we'll wrap up another episode of Serious Privacy. If you like these episodes, please like us in your favorite podcast app, leave a review. If you want to join the conversation, especially on this topic, find us on LinkedIn under Serious Privacy. You will find Kay on Twitter and other social media as Heart of Privacy, and myself as Europol D. Until next week, goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.